Well, good afternoon. Good afternoon. It's great to be here. What a pleasure it is to be here. I spent more than 3 decades on the East Coast. I have lots of connections here in DC. And as Randy mentioned, we go way back. I also go way back here at this law school. My mentor was someone who teaches here now, Rob Glicksman. I've learned so much from Randy through the years. It's great to be here with Ira as well. We've been working with the American Bar Association for a long time together, and also working together with Mary Ann Grena on over 30 years on a variety of things. And I could go on and on, but I just so appreciate the invitation. And thank you for coming back from lunch to hear something just some nobody from Kansas has to say about any of this. My job is to share some thoughts about what the Constitution has to say about the things that you've been hearing about displaced communities or receiving communities and climate migration and so on. And mine is a constitutional perspective. So that's because constitutions are where we declare what we value and how we're willing to abide by kind of the Hobbesian social contract, how we treat each other, what we say to each other, what we expect from each other. Because the government is just you. It's just us. It's what we're willing to allow to happen. And that's reflected in a constitution. It's no small matter. Lots of people have given their lives through, millennia to live under a constitution. So it's good not to take it for granted. So there's no time to waste, and not to go into too much of the parade of horribles. The planet reminds us of why there's no time to waste. 2025 will be warmer than 2024, which was the warmest year on record, and warmer than 2023, and so on. 2026 will be warmer than 2025. And on and on. It's a little like falling in love. Wait for it. So like a little at a time and then all at once with migration, with displacement. It's in dribs and drabs. It's whether it's 13 million or 30 million, but man, there's gonna be a reckoning at some point in time. We're going to make some hard choices. And if we still have the constitutional system that we're living under now, right? There are these constitutional questions about whether the Constitution can accommodate all of this migration, this displacement, and the impact on receiving communities. So that's what I'll be sharing some ideas about. I'll also be talking about, or trying to talk about, kind of how we got here, why it is that at least the federal judiciary in the United States has been so silent about climate change. And then maybe where some places, because I don't want to leave you with that. And then maybe some places to look for hope. I'll focus on mostly, however, the federal Constitution and receiving communities. And raise your hand if you've had constitutional law. I'm just curious. I'm not going to call on you, so it's okay. But some of you teach it, I know. But so constitutional law, it's not just the Constitution. We have this weird system. We don't think of it as weird because it's all we've ever known. It's like, if you have a weird brother or sister or sibling, and they never seem weird to you, but then they seem weird to, you just don't see it if you're that close to it sometimes. But, we don't have a constitutional court. Lots of countries do. Most countries do, that decide constitutional questions. We have a Supreme Court, which a lot of countries have, that rules on everything. And that court decided that it could rule on everything in 1803 in this Marbury versus Madison case. So what I mean is that constitutional law isn't only the Constitution. It's also what the federal courts say the law is, because that's law too. So let me map some constitutional authority that both accommodates and hampers climate displacement and receiving communities. And then I'll explain why the federal judiciary seems ill-equipped to handle climate displacement. Sorry, spoiler alert. And also look to how it's dealt with other similar questions about receiving communities and sustainability. And then I'll look to the confirmation process for federal judges to try to get some answers there. But first, the constitutional authority for and limitations on climate displacement. The question is whether the federal government has authority to handle this. During lunch, which was wonderful, by the way, as someone who's vegan, to see just a sea of vegan lunch boxes. Like in my whole life, I don't think I've ever seen that before. I'm the one who's like picking through the box to eat. Thank you, by the way. It's likely that Congress has authority to address the climate displacement emergency that awaits us under various provisions of the Constitution. First, the Commerce Clause. Yes, I know some of you students will have flashbacks. We'll get through this together. It won't take long. But it provides that Congress shall have the power to regulate commerce among the several states. And what the Supreme Court has said that means is that it permits Congress to regulate in three ways: channels, instrumentalities, and also activities that alone or in the aggregate substantially affect interstate commerce. So it's likely that Congress, if it gets involved in this game, that authority would be upheld under one of those theories. Second, and I have to say as well, there's a whole lot more to talk about with any of these questions or any of these issues. And so we'll hopefully have some time, and it still won't be enough. These are contested questions that go back 230 years in our country. But a second source of authority for Congress in this discussion is probably the Spending and General Welfare Clause, which permits Congress to tax and spend to provide for the common defense and general welfare of the United States. And it can do that by attaching conditions to the receipt of federal funds, provided that the conditions aren't what's called coercive. Now, you have to incentivize, give the states a reason to get involved through this bargain we made, this dance of cooperative federalism. And so, given the jurisprudence from the Supreme Court, on that score, it's likely that Congress could also establish mechanisms for inducing, but not conducing, responses to climate displacement, including for receiving communities. Third, about 28%, give or take, at least as of, 1:45 or so today, about 28% of federal lands, of the lands in the United States is in federal hands, is managed by the federal government. Again, I can't promise by 4 p.m. today. I don't know. We're laughing now. But there's a property clause that allows Congress to make all, and I'm quoting, needful, end quote, rules concerning federal land. And courts have interpreted that as being authority that is, quoting again, virtually without limitation. And with this authority, Congress has enacted lots of laws allowing for the development on exploitation in federal lands. There's also an enclave clause in the Constitution that gives Congress authority to set up federal enclaves, like the White House. So Congress has authority to develop land, to set aside land. Again, I'm not suggesting it's the best way or it's optimal, but it's an option to accommodate climate displacement. Finally, states can't prevent climate change-affected citizens from moving across their borders through something called the Privileges and Immunities Clause, which says that no state shall enforce any law which shall abridge the privileges or immunities of its citizen. And the Supreme Court has said, really, again, I'm compressing so much for those of you who teach con law, I know, but it said that states have to permit people to travel among states, including to relocate, including to live. Okay, and with that, let me turn to some of the constitutional impediments faced by Congress and others in serving interests of receiving communities. First, relocating people could implicate what's called the due process clause and substantive due process. The first time I heard that, when I was in law school, as Randy mentioned, I was an engineer. I couldn't pronounce the word or spell it. I didn't know what it meant. It's not in the Constitution, but what it stands for. It's where we find fundamental rights in our Constitution, because we really don't have them in the federal Constitution. Some civil and political, amendments 1 through 8, I know arguably 1 through 11, but that's where we find our, but they're not really socioeconomic and cultural rights, any expressed there. So we make them up. There are unenumerated rights that we read into the due process clause. So that's oftentimes where courts look to see whether those rights have been infringed. So it might be further fodder for considerations about whether there's a fundamental right to relocate and a fundamental right to be accommodated in that location process. Relocating people could also implicate what's called the takings clause of the Fifth Amendment. The Fifth Amendment to the Constitution forbids the taking of private property for public use without just compensation. So the government can take, it does, eminent domain, it just has to pay just compensation. So again, one can imagine situations we're talking about today, a lot of the conversation today, again, it's my constant, it's the way I'm wired now. I'm thinking, well, gosh, to relocate communities or to require communities to accept those who've been displaced, that's a Fifth Amendment issue coming and going. So the government would have to compensate, arguably, right? I mean, there aren't cases about it, so I don't know how it would work out, but it might certainly give federal, state, and local authorities some pause before instituting federal programs. I'm not talking about private governance or private programs, but federal or even state or local programs, governmental programs in the sphere could implicate Fifth Amendment taking and cost an awful lot of money. Third, displacement could implicate the Equal Protection Clause, which provides, quote, "Nor shall any state deny to any person within its jurisdiction the equal protection of the laws." The U.S. Supreme Court has held that this clause is triggered by evidence of invidious express or intentional discrimination based upon race, ethnicity, or national origin. So you might think, if you didn't know any better, like I didn't know any better when I was in law school, equal protection. No. It's triggered, is the expression, by mistreatment involving so-called suspect classes, but in purposeful ways, like you meant to discriminate. And if that can't be proven, then the Equal Protection Clause does not provide a cause of action. The Civil Rights Act might, but the Equal Protection Clause doesn't. So while thus far no court has held that climate policies, contravene equal protection, because the arguments can be made, right? Vulnerable communities are more likely to be affected. Children are most likely to be affected over their lifetimes more than me. And I was about to say more than Randy too, but I don't want to give away his age too. So managed retreat could, however, invite a conversation about what's called heightened scrutiny as it affects those populations. Finally, a federal program linking managed retreat and receiving communities could run afoul of the 10th Amendment, which reserves powers not expressly delegated to the federal government nor withheld from the states for the states. For example, a federal law that required states to take title of low-level radioactive wastes. This is the New York versus United States case, for those of you who have probably read about it. The Supreme Court said that was unconstitutional because it would it would have the federal government, in essence, commandeer state resources. See, we're not the average bear when it comes to setting up a republic. We're the only republic, the United States, the only republic of its kind, where we split the atom of sovereignty, where states are sovereign. Now, there are other republics that have a federal government and states, like Brazil, but the states serve really, and those of you from Brazil, again, forgive me, but the states there really serve the federal government or federal governmental policies by and large. We don't do that. I mean, we can, but states can take a pass. And federal government can't commandeer state resources to implement climate policies or displacement policies. So that's a limitation. So as Ira Feldman and I have written, several questions could test the Constitution's flexibility and influence, the choice between what to do, whether to do it now or in 5 years or 10 years later or never. Questions like, will the right to freely travel across state borders always be protected? Will states' priority in land use decisions be questioned in matters of human habitability, environmental sensitivity, industrial relocation, and reestablishing livelihoods? A lot of, again, what I heard in lunchtime conversation that I was a part of. Can public land, including military bases, parks, BLM land, federal enclaves, and other protected areas be taken, swapped, or repurposed into becoming a receiving community? So thus far, and here's the drum roll, right? But don't. Thus far, the US federal judiciary hardly seems ready to engage these questions. According to the Sabin Center at Columbia School of Law, there have been nearly 3,000 climate litigation cases, all time, give or take, right? The US is responsible for 2 out of 3, so roughly 2,000 of those. And yes, I feel like I've worked in all of them at this point. So many US cases involve what are called common law claims, like for fraud or trespass or nuisance or negligence against big oil companies or corporations. Those aren't constitutional claims. And in our nation's history, none. I didn't think I'd say this at this point in my career, none have gone to trial. None of those cases have gone to trial. And very few are climate rights cases of those 2,000 or so, very few. You can count them on both hands. I can. And these are cases brought to vindicate a right to a stable climate. Some are federal, like the Juliana case, but most are at the state level, in Montana, in Pennsylvania, in Florida, New Mexico, and Hawaii. I could go on. But very few involve this displacement question, at least at the federal level. A case I worked on that maybe came close was the Kivalina case about, in essence, climate-caused displacement and what to do about it. It was still a common law cause of action. It was thrown out under the jurisprudence from the US Supreme Court, which ruled that the Clean Air Act and federal law displaces federal common law, whether it's implemented or not. So why the reluctance to weigh in from federal courts in the United States? Again, I don't know, right? And there's not a monolithic answer. So, take this with a grain of salt. But courts in the US are reluctant to address really most environmental issues, even when there's an international, regional, and subnational law that could light the way. The example I'm thinking of is something that's related to resilience and receiving communities and sort of the beck and call along the way of so much discussion about these issues, which is sustainability. So nearly 35 years ago, the World Commission on Environment and Development issued a pioneering report, Our Common Future, which introduced this idea of sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. And that's a common denominator to so much, for me, as I'm processing it, so much of today's conversation. To me, it's echoes of sustainability. So compressing a lot, the UN, including the United States, but the United Nations agreed to what are called 17 Sustainable Development Goals. They ain't law, but they're legalish. They hold moral suasion. They're recognized in international law, but when I say they're not law, you can't enforce them. You can't bring an action before an international court for failure to abide by the sustainable development, things like that. But they're enormously popular and enormously influential all across the globe. The first floor of the United Nations I don't know if it's still this way, but when I used to be a member of the UN Sustainability Commission, it has a different name now. It's all about sustainable development. You know, you can buy yourself a sustainable development tie, a mug, a shirt, a hairband. Do I lie? You know, you're talking about, right? So no doubt sustainable development principles have informed policies in practice in America, but there remains one bastion where the word sustainability or sustainable development or anything like it isn't uttered or written or acknowledged. U.S. federal courts. For example, the United States Supreme Court and nearly every entity of the federal judiciary has, well, just about ignored that expression. Now, almost 50 years on, it seems reasonable to expect that at least one member of the most influential juridical body on the planet, arguably, right, would have found a case or cause or a controversy befitting mention of what many hold as the common feature in law and environmental policy across the globe. Yet this hasn't happened. Here's some numbers at you. 116 people have served on the U.S. Supreme Court, including 19 since what some would call the onset of environmental law in 1970. Moreover, the U.S. Supreme Court, or numbers, has issued around 30,000 decisions since 1791, 30,000 decisions. Hundreds touch or concern principles of sustainability, principles of climate, principles of displacement, but no justice and no case, however, invokes any expression in the sustainability oeuvre, including sustainable development goals, sustainability, and none reach climate displacement. I mean, there's an argument that it was raised kind of in the Massachusetts versus EPA case, or in American Electric Power versus Connecticut. I mean, okay, you know, because it was kind of in there in the mix a little bit, but no merits were ever reached in those cases that way. So part of the explanation for this is how we choose judges, and I'm going to get myself into trouble here, maybe. There are 94 federal trial courts. We call them district courts. So 94 federal trial courts throughout the country. There are 13 federal courts of appeal and one Supreme Court. There are all sorts of other courts too. I don't mean Article I courts, I mean Article III courts. And Article III judges, presently there are about 1,500 of them throughout the United States. And that's at those various levels. You know, there are more at the district court level, and then the appellate court level, and then there are, we have 9 in the Supreme Court. So every one of them were nominated by a president and confirmed by the Senate. And confirmed by most of them went through the Senate Judiciary Committee, which hears these nominations. The Senate Judiciary Committee not only holds hearings on judicial nominations, notwithstanding the name, lots of other nominations as well. Pretty much if you have any sort of enforcement authority in the federal government, you go through the Judiciary Committee. Now again, some of you know far better, but I'm just very generally. It has a lot of authority, it holds lots of hearings, and confirmation is one of its key purposes. So for the U.S. Attorney General goes to that committee, DOJ appointees, FBI, intellectual, and what I learned about today, the intellectual property officer goes through the Senate Judiciary Committee. I mean, who knew? I didn't even know there was one. This can involve a hearing process where appointees apply by completing a detailed questionnaire. I'm just curious, have any of you filled out one of those judicial questionnaires? I'm not going to call on you, but it's what you do. It's super detailed. You know that form you fill out when you go visit a physician for the first time? You know, it's way more than that. I mean, all sorts of questions: where you went to school, what grades you got, what you published, where you published, what you presented, what you said. Is there a transcript? It's rigorous. But at the hearings, then, with all this information, the senators ask questions or have the opportunity to ask questions. And generally, the nomination process focuses on the nominees' judicial philosophy, qualifications, and past rulings. I wondered whether, and the extent to which either nominees for any of those posts were asked about climate change. or global warming, or again, climate displacement, anything that we're talking about today. And according to ProQuest Professional, I'm not an agent of it or a salesperson for it, but it's a search platform that collates congressional hearings and going back to 1831. According to that, more than 20,000 people have been nominated for federal judgeships, Article III judgeships, including more than 1,000 people just this century, when the science, right, seems settled that climate change is real and was the subject of growing litigation. Yet, in that time, again, by my count, and I invite anybody to correct this. I've sent emails onto listservs. By my count, only 5 have ever been asked anything about climate. Again, I was surprised by that. I hope I'm wrong. Not only that, I couldn't find any questionnaire responses. I didn't have access to all of them, just the ones that were on ProQuest that were part of the nomination proceedings, which can be 1,000 to 1,500 pages long. I couldn't find any responses in the questionnaires where the nominee said anything about climate change. A couple of them had given presentations or presided over conferences like this one or something, but when they were expressing their points of view about this, that, or the other thing, nothing. And not only that, but the questioning in the hearings is ordinarily one that one might call perfunctory. Okay, I guess I'm calling it perfunctory. In 2010, the closer we get to more searching questions, in 2010, for example, Senator Feinstein asked nominee Kagan whether people who are harmed by climate change have standing to bring cases. In 2011, Senator Grassley asked a nominee for the federal bench about the concerns that he had about judicial activism in the case of Massachusetts versus EPA. So he was complaining about it. He wanted to hear points of view. Sometimes judges can raise it or raise environmental senators. Senator Leahy has asked about climate. Schumer, Specter, Coons, but again, not much. Senator Whitehouse, Blumenthal, Hirono have mentioned it, but no questions have touched or involved managed retreat or resilience or constitutional demand. I mean, of the kind of things that we're talking about, again, like falling in love. These are questions that have to be addressed. It's going to happen. So judicial sidelining is concerning. The dearth of constitutional authority limits not just the structure of our core federal environmental statutes, but also the way that they're interpreted and applied. And in the absence of clear and broad authority to protect the climate, it limits what the judiciary can do and what the public can expect. And in addition to failing to give the federal government clear power to protect the environment, the Constitution also fails to impose clear limits on the federal government's power to exploit or harm the environment, including the climate. The Constitution's failure to identify limits on governmental harm to the environment compounds the lack of express power to act and protect the climate. To appreciate how constitutional silence on the climate contributes to constitutional hostility to environmental protection, it's important to recall that the Constitution is pretty clear about property rights. It allows other values like private property, speech, states' rights, explicit recognition. So imagine a constitution that has explicit recognition for other values and fits the time. All right, so let me finish with hope and then dash it for you. There's hope for more judicial engagement of resilient communities and managed retreat issues at the state level. Most of my talk is about the federal government, the federal judiciary. But again, we split the atom of sovereignty. Every state in our country has its own constitution. And also every U.S. holding, American Samoa, the Mariana Islands, Puerto Rico, constitutions. And so that's another place to look for rights. Many of them reflect socioeconomic and cultural rights. or rights that can be thought of like that, that the federal government doesn't have. And we see over the last 5 years or so an emergence of climate issues being litigated in or at the state level. Montana is the best example, where the Supreme Court of Montana ruled just a few months ago that a lower court's ruling finding that the right to a healthful environment in the Montana Constitution incorporated a right to live in a stable climate. That's one example. There are other cases working their way up the chain, and maybe some headed to trial, like in Hawaii. So there's more happening there. There are other cases, again, New Mexico, Utah, Virginia, Washington, Florida, all over the place. So let 1,000 flowers bloom if we believe in that idea of splitting the atom of sovereignty and seeing where it goes. Another source of hope is growing recognition of human dignity under law. This was mentioned before the luncheon as well. Internationally, more than 160 constitutions guarantee a right to human dignity. Yes, not just as a value or as a norm, as a right. And some places do in the US, Puerto Rico's constitution, Montana's constitution, American Samoa's constitution. And at the federal level, there's more recognition of it. Where we see this coming up, the bridge to today's conversation, is that across the globe, it's being used in the climate migration context. How to advance human dignity in that process and to recognize it. But taking current stock in some, in final remarks here, it isn't encouraging at the moment. The Constitution, as presently worded, interpreted, and applied, is obstructing the development of a robust societal response to climate change and climate displacement, in part by failing adequately to protect a healthy democratic process and advance real social justice and everything else that's going on a few hundred yards from here. Of course, we could amend the Constitution to support values that address the issues that we've been talking about here. We could also encourage judges and those who are nominated to welcome new understandings of existing constitutional texts that cognize the fundamental value of a stable climate. Any approach will require an open-eyed reckoning with how and why the constitutional status quo is failing to meet the climate moment. And what I vote for? I vote, given our constitutional history and great cases that have changed society for the better, I vote for making the Constitution great again. Thank you. So Randy, I think that's 5 after-ish, so hopefully.
Time for a few questions.
Yes, thank you.
Thank you for your presentation. You mentioned that the right to cross state lines was potentially an interpretive right rather than a strictly enumerated right. Are you worried that that is something that is potentially at risk?
Am I worried about it? I just think that it has been litigated. It has been subject to an alternate ruling than where we are now. So I think these days, again, I don't know. Again, given what's going on, I don't know. But I think anything is possible. And I think it's possible that some states, again, as climate displacement becomes the order of the day, will close their borders. And who's to stop them? I mean, I hope it doesn't come to that. But that can't be the only question. It's so depressing. Yes, go ahead, thank you.
So I have a little bit of an advantage having co-authored a paper with you. I want to pick up on the last sentence in your presentation. You talked about two options, either amending the Constitution or judicially reinterpreting existing language. In our joint publication, you talked about constitutional revolution, and I thought the audience might find that concept interesting to understand what you meant by that.
Sure. So Ira and I wrote a piece about climate displacement uh, and constitutional values and outcomes as well. And one part of it was to wonder whether there should be a reinterpretation of some of these provisions, like the one that you're talking about. Which way would that go? I think the idea of a constitutional amendment per se, an express one, addressing any environmental value under present conditions is a long shot. It's about as likely as the Eagles winning the world. I mean, I flew the Super Bowl. I was kidding. But the revolutions part is recognizing the power that courts have. I mean, courts make the law. So a way to change the law is by changing who we choose and how we choose them in the system. And that was actually a phrase coined by a former colleague of mine. His name is Robert Lipkin. But that's what he was talking about, that there are these times in our nation's history where there have been constitutional revolutions. No, I don't mean, taking up arms and things. I mean, kind of reinterpreting the Constitution. We've seen that, those kind of, had con law with interpreting the Equal Protection Clause, the Due Process Clause, the Commerce Clause, that, fill in the blank. There have been revolutions along the way that changed how we think of it. So that's what we wrote about. Is a time to, rethink how judges think about these issues. Yes, thank you.
I have a question to that last point that you made, how we need to change how we choose, and why would the judges that are currently in power, or the people that are currently enforcing how judges are chosen, why would they cede that power to allow new judges with different perspectives to come onto the court?
Why would they cede?
Why would they, if the people in power, why would they have any desire to make those changes? Because as it is right now, the people in power are powerful. Why would they want to allow these changes to occur? Does that make sense?
Yeah, I think so. And
Yeah.
an answer, and again, I'm not saying I don't, but an answer will be simple, and I trust super frustrating as well. And that is vote. Why senators, many of them have a D after their name, would never ask about climate, not even ask about, I don't know. But, we have a representational reinforcing democracy. Senators are directly elected, for example. So if the electorate made it an issue, then maybe senators would pay more attention to it. So maybe that's a reflection of all of us too. Randy.
So I was thinking along the lines that you had cynicism, realism, a sense of doom, however you want to characterize it.
It's quite a progression. Cynicism, realism, doom. Where am I?
Rightfully so, about hope for our judiciary getting this right, and particularly our current composition of the Supreme Court. But I'm trying to think as optimistically as possible. I'm thinking somewhat recent examples of where a largely conservative court reached a good outcome in terms of social justice issues. So I'm thinking about the Obergefell case in 2015, recognizing a broad interpretation of our due process clause to recognize the right to same-sex marriage, and the decision upholding the constitutional validity of the Affordable Care Act. So there are sort of limited examples where the court gets it right, perhaps on things that the court didn't perceive to be as liberally labeled as other issues. So I think a right to environmental protection of any kind is probably not going to happen. I agree with you there. But when you think about these issues of climate migration, that idea of a right to dignity is much more of a nonpartisan thing. When we have things in the news like the LA wildfires and how, regardless of your political stripes, this is affecting all of us, and can't we find some way for the Constitution to recognize some common baseline that is we care about ourselves as fellow humans, the Constitution can do something more to ensure a baseline of protection for all of us on the basis of right to dignity, shelter, food, water, however we characterize it, just not as an environmental right.
Yeah, no, I think that's a great point. You know, the chief proponent in the U.S. Supreme Court for those values that you just mentioned, it was Justice Kennedy, you know, author of the Obergefell decision, Lawrence, and so on. And it was based upon this right of dignity, you know, recognition that everybody has equal worth, and also this social contract we have with each other, you know, to be decent. And but when he retired, the Supreme Court, the justices haven't turned back to that, except in dissent in Dobbs. You know, so the dignity was a feature of the Casey case, you know, about, you know, concerning reproductive rights. And Justice O'Connor pretty much said, you know, these reproductive rights go to the core of who we are, our self-autonomy and our dignity, you know, using that word. So that word was used, kind of echoed in reproductive rights jurisprudence throughout the country for a while. But in the Dobbs case, it was turned on its head, and, you know, dignity was not foregrounded. But I tend to agree with you. I mean, just as you know, what I value, I like the sound of dignity under law, and I think it can serve interests, a lot of interests when we're talking about displacing people, you know, acceptance and the rest of it. So I think dignity does have a role. I also think, again, it underscores the importance of subnational constitutionalism, and we can look for answers there. The framers of the Constitution intended that we would. So, you know, I don't know if I'll live to see it, but I hope that there will be, getting back to Ira's question or point, constitutional revolutions there. But let me just say again, what a pleasure it's been. I'm Jimmy May. I live in Kansas. If you're in the area or if you just want to reach out, you know how to find me. So thanks so much.